Nevada Construction Business and Law Manual, Chapter 4. Job safety and environmental safety. Safety at the construction site must be one of the highest priorities for the construction company. Failure to address this issue in a comprehensive manner could result in employee and employer losses and legal consequences that could be disastrous to the company. The responsibility for the safety and health of everyone involved in the project belongs to the contractor with the assistance of employees and all others who are involved with the construction project. Value of safety. Safety first should not merely be a slogan, it should be a fully developed and implemented plan involving all of a company's employees and its subcontractors. The plan must be initiated, approved, and supported at the highest levels in the company. It is very important that the plan be in place before a project begins. Elements of the plan should include safety committees, training by safety consultants and experts, safety meetings, and effective communication to everyone through bulletins, notices, and posters. Federal, state, local, and company safety regulations must be fully understood by all and posted in areas that allow them to be readily seen and referred to, with the goal of zero accidents. A good safety program that identifies safety problems and provides the means for correcting them is an ongoing process that should be updated and upgraded on a continuing basis. In addition, hazardous or unsafe conditions on the job may require immediate action beyond any formal regulations. Employees can be the frontline defense against unsafe conditions and practices. The benefits of a well-developed safety program are many and include increased worker time on the job due to few injuries and fatalities, increased availability of skilled and trained workers, lower medical expenses for both the contractor and employees in the form of reduced workers' compensation costs and other insurance premiums, as well as fewer out-of-pocket expenses, less downtime due to the equipment breakdown or damage, reduced downtime and costs associated with fines, citations due to the violations of rules and regulations, fewer lawsuits and liability issues, and improved company image that could result in increased business. In summary, the accrued benefits result in improved employee relations and greater company profits. There are many resources available for obtaining information and guidance in the area of construction safety and health. For example, the Construction Industry Institute, CII, established in 1983, is an organization leading owners, contractors, and suppliers. A major goal of the group is the improvement of safety in the construction industry. The CII can be contacted at Construction Industry Institute, 3925 West Breaker Lane, or 4500 Austin, Texas, 78759. Phone number 512-232-3000. https://www.construction-institute.org/ Occupational Safety and Health Act, OSHA. The Electronic Communications Privacy Act. Occupational Safety and Health Act, OSHA. The Occupational Safety and Health Act, OSHA, of 1970 was created to ensure safe and healthful working conditions for employees in the private sector. 28 states have automatically adopted this law, while the remaining 22 discretionary states have the option of adopting the OSHA rule, publishing their own regulations or developing voluntary guidelines for state and local employees. State and local governments which adopt their own safety and health plans must make sure that they are at least effective as the federal law. For specific information concerning the state's OSHA law, refer to Chapter 9, Business Requirements. OSHA Safety Programs. According to 29 CFR 1926, employers should take advantage of safety programs provided by OSHA. In addition, the employers must comply with any specific regulation that apply to work in dangerous or potentially dangerous areas, provide instruction for employees in the safe handling and use of hazardous materials, and make them aware of the specific requirements 29 CFR 1926 and provide instructions for employees in the safe handling or use of poisons, caustics, and other harmful substances, and make them aware of the potential hazards, personal hygiene, and personal protective measures required. OSHA plays a critical role in supporting the Department of Labor Quality Workplaces goal by carrying out programs designed to save lives, prevent injuries and illnesses, and protect the health of workers. These programs include developing guidance and standards for occupational safety and health, inspecting places of employment and working with employers and employees, offering consultation services to small businesses, providing compliance assistance, outreach, education, and other cooperative programs for employers and employees, providing matching grants to assist states in administering consultation projects and approved occupational safety and health enforcement programs, and fostering relationships with other agencies and organizations in order to address critical safety and health issues. OSHA Training Institutes, OTI. OSHA has established regional training centers that offer courses which train workers and employers to recognize, avoid, and prevent safety and health hazards in their workplace. Many OSHA Training Institutes education centers offer new training methods to help employers reduce work-related injuries and illnesses, and in turn result in a positive impact on the company's bottom line. These centers are incorporating web-based learning, known as blending learning. Students who enroll in blended learning courses must complete a web-based training portion of the course before attending the resident training portion of the course. Training centers across the United States make classes available in many regions. For a list of regional training sites and to obtain specific information about their locations, course offerings, and schedules, access the OSHA https://www.osha.gov/DTE/ED-centers/. The OSHA Office of Training and Educational Training Resources can be contacted for additional information or enroll students. The registration office can be reached at the following number: 847-297-4810. OSHA Strategic Partnership Program. The OSHA Strategic Partnership Program for Worker Safety and Health, OSPP, is an expansion of OSHA's previous experience with voluntary programs. In carrying out this program, OSHA enters into an extended voluntary relationship with groups of employers, employees, and employee representatives, or sometimes only one employer, to assist them and to recognize their efforts to eliminate serious hazards and achieve a high level of worker safety and health. Most of the partnering work sites are small business with an average of 22 workers. Many of these partnerships include businesses in the construction industry. http://www.osha.gov/dcs/partnerships/index.html. Outreach materials on OSHA's website. OSHA's website provides extensive information about the agency as well as explanations about the standards. A 44-page booklet entitled All About OSHA can be found on the following website: http://www.osha.gov/PLS/publications/PTYPE=ATHRUZ #A. The site also includes eTools, interactive software with information about specific health and safety topics and regulations. OSHA also produces Quick Takes, a bi-monthly e-news memo filled with timely information updates and results about safety and health in America's workplace. Subscriptions are free and can be ordered on the website. In addition, OSHA's website includes several special features: Spanish language pages, small business page, workers page that explains workers' rights and responsibilities, teen workers page that addresses safety and health issues for workers under the age of 18. The website is http://www.osha.gov. Recording and reporting occupational injuries. The Occupational Safety and Health Act, OSHA, requires that employers investigate and report all work-related injuries. This includes occupational diseases and unusual occurrences that may have resulted from unsafe exposures to hazards. The Act specifies the OSHA office where the information must be sent, the time limits for reporting work-related deaths, and the time limits for reporting accidents involving multiple numbers of employees. OSHA requires that employers follow the guidelines mandated by the law in determining whether a worker is an employee or an independent contractor. This determines who must keep records and who could also determine the size of a small company and its requirements for recording injuries and illnesses. Additional information concerning distinctions between employees and independent contractors can be found in Chapter 3, Labor Management, in the section entitled Employee versus Independent Contractor. Contractors with 10 or fewer employees do not have to keep injury and illness records unless specifically requested to do so by the Bureau of Labor Statistics, but must report accidents or hospitalizations that involve 3 or more workers. In either case, a report must be made to OSHA within 8 hours of the incident. Contractors having more than 10 employees must maintain records of all work-related injuries and illnesses, regardless of how minor. OSHA record-keeping forms. Copies of 3 OSHA forms used by employers for record-keeping have been included in this chapter immediately following this section. These are Form 300, Log of Work-Related Injuries and Illnesses. Form 300 is filled out when work-related injuries or illnesses occur. Information required on this form includes personal information about the workers being reported, and severity of the injuries or occupational illnesses. Each incident must be logged on this form within 6 days from when the employer learns of injury or illness. The employer must keep this form for 5 years for each of the incidents reported on the form. A separate form, Form 301, Injuries and Illnesses Incident Report, must be filled out and filed. Form 300A, Summary of Work-Related Injuries and Illnesses. Form 300A is used to report an annual summary of the injuries and occupational illnesses that occurred during the year and must be prepared even if there were no injuries or occupational illnesses. Form 301, Injuries and Illnesses Incident Report. Form 301 is one of the first forms that must be filled out when a recordable work-related injury or illness has occurred and must be filled out within 7 days from the notification of the injury or illness. More detailed information, an employer may obtain a copy, record-keeping guidelines for occupational injuries and illnesses from the United States Department of Labor, and the website is https://www.osha.gov/recordkeeping/. And this is a example of OSHA's Form 300. This is an example of the 300A. And the 301. OSHA 29 CFR 1904, Recording and Reporting Occupational Illness Injuries. One specific part of the federal OSHA law is 29 CFR 1904, Recording and Reporting Occupational Illness Injuries, which has a particular significance for the construction industry because of the type of work performed can lead to injuries if proper safety rules are not implemented and followed. When work-related injuries or illnesses do occur, the contractor must be aware of OSHA's reporting requirements in order to fulfill them and to avoid paying large penalties. The following information was summarized from 29 CFR 1904, Recording and Reporting Occupational Illness Injuries. Recording criteria. Each employer is required to keep records of fatalities, injuries, and illnesses that are work-related or are new cases and meet OSHA's recording requirements. Any work-related facility must be reported to OSHA within 8 hours. In order to record an injury or illness that results in death, the employer must check mark on the OSHA 300 log in the space noted for recording incidents resulting in death. Basic requirements. To meet the basic requirements, the employer must consider that an injury or illness is recordable if it results in any of the following. 1. Death, days away from work, restricted work or transfer to another job, medical treatment beyond first aid, or loss of consciousness. Or 2. A significant injury or illness diagnosed by a physician or other licensed health care professional. Decision tree. The decision tree for recording work-related injuries and illnesses shown below in Figure 4-4 illustrates the steps involved in deciding whether a worker's injury or illness is recordable. Figure 4-4, recordable injury or illness decision tree. Did the employee experience an injury or an illness? Yes or no? Yes. Is the injury or illness work-related? Yes or no? Yes. Is the injury or illness a new case? Yes or no? Yes. Does the injury or illness meet the general recording criteria or the application to specific cases? Yes or no? Yes. Record the injury or illness. If you step back, is the injury or illness a new case? No. If necessary, update the records of the former injury. Forward. Does the injury or illness meet the general recording criteria or the application to specific cases? No. Do not record the injury or illness. Determining work-relatedness. The employer must consider an injury or illness to be work-related if in an event or an exposure in the work environment either caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. If an employee is involved in work-related travel, injuries, and illnesses that occur are considered work-related if at the time of the injury or illness the employee was engaged in work activities. There are some exceptions, as noted in 1904, where an injury or illness occurs in the work environment but is not considered work-related. Refer to CFR 1904 for exceptions. Determining new cases. An employer must consider an injury or illness to be a new case if the employee had not previously experienced a recorded injury or illness of the same type that affects the same part of the body, or had previously experienced a recorded injury or illness of the same type that affected the same part of the body but had never recovered completely. OSHA penalties. OSHA personnel often make on-site inspections. Violations of the safety law can result in citations being issued and penalties being assessed. Penalties can range from $1,000 to $70,000. Among the violations for which OSHA will assess penalties are failure to maintain or provide access to records, report injuries or illnesses, maintain logs, post OSHA or state posters or notices, or provide honest information. The following information has been summarized: OSHA Civil Penalties Policy from the OSHA document entitled New OSHA Civil Penalties Policy. To provide information necessary for compliance with the OSHA requirements, a 7-fold increase in the maximum limits of OSHA civil monetary penalties was stipulated in the Budget Reconciliation Act passed by the 101 Street Congress. The maximum allowable penalty is now $70,000 for each willful or repeated violation and $7,000 for each serious or other than serious violation, as well as $7,000 for each day beyond a stated abatement date for failure to correct a violation. The amount are ceilings, not floors. However, in order to ensure that the most flagrant violators are in fact fined at an effective level, a minimum penalty of $5,000 for a willful violation of the OSHA Act was adopted. The new penalty policy will be applicable to all citations issued as a result of inspections initiated after March 1st, 1991. The violations occurring after November 5th, 1990, the effective date of the Budget Reconciliation Act. The new policy also applies to those with OSHA-approved state occupational safety and health programs, under the congressional direction that these state plans must be at least as effective as the national plan. The participating states are being given a reasonable period to implement the new penalty structure, which takes into account the state's legislative calendar. Adjustment factors. Employers could qualify for the full 25% good faith reduction of the penalty if they have a written and implemented safety and health program, such as given in OSHA's Voluntary Safety and Health Management Guidelines. Federal Register, Volume 54, Number 16, January 26, 1989, pp. 3904-3916. And that includes programs required under OSHA standards, such as hazard communication, lockout tagout, or safety and health programs for construction required in CFR 29/1926-.20. Serious violations. A serious violation is defined as one in which there is a substantial probability that death or serious physical harm could result, and the employer knew or should have known the hazard. Regulatory violations involve violations of posting, injury and illness reporting, and record-keeping requirements, and not telling employees about advance notice of an inspection. Here are the base penalties before adjustments. To be proposed for posting requirement violations: OSHA notice, $1,000. Annual summary, $1,000. And failure to post citations, $3,000. Base reporting and record-keeping penalties are as follows. Failure to maintain OSHA 200 and OSHA 101 forms, $1,000. Failure to report a fatality or catastrophe within 48 hours, $5,000, with a provision that the OSHA regional administrator could adjust that up to $7,000 in exceptional circumstances. Denying access to records, $1,000, and not telling employees about advance notice of an inspection, $2,000. Willful violations. In the case of willful serious violations, the initial proposed penalty has to be between $5,000 and $70,000. OSHA calculates that the penalty for the underlying serious violation, adjusts it for size and history, and multiplies it by 7. The multiplier of 7 can be adjusted upward or down at OSHA regional administrator's discretion. If circumstances warrant, the minimum willful serious penalty is $5,000. Willful violations are those committed with an intentional disregard of or plain indifference to the requirements of the OSHA Act and regulations. Repeat violations. A repeat violation is violation of any standard, regulation, rule, or order where, upon reinspection, a substantially similar violation is found. Repeat violations will only be adjusted for size, and the adjusted penalties will then be multiplied by 2, 5, or 10. The multiplier for small employers, 250 employees or fewer, is 2 for the first instance of a repeat violation, and 5 for the second repeat. However, OSHA Regional Administrator has the authority to use a multiplication factor of up to 10 on a case involving a repeat violation by a small employer to achieve the unnecessary deterrent effect. The multiplier for large employers, 250 or more employees, is 5 for the first instance of a repeat violation and 10 for the second repeat. If the initial violation was other than serious without a penalty being assessed, then the penalty will be $200 for the first repetition of that violation, $500 for the second repeat, and $1,000 for the third repeat. Failure to abate. Failure to correct a prior violation within the prescribed abatement period could result in a penalty for each day the violation continues beyond the abatement date. In these failure to abate cases, the daily penalty will be equal to the amount of the initial penalty up to $7,000. This failure to abate penalty may be assessed for a maximum of 30 days by the OSHA area office. In cases of partial abatement of the violation, the OSHA Regional Administrator has the authority to reduce a penalty by 25 to 75%. If the failure to abate is more than 30 days, it may be referred to the OSHA National Office in Washington, where a determination may be made to assess a daily penalty beyond the initial 30 days. Reference: the information about civil penalties is intended as a general description only and does not carry the force of legal opinion.